Good afternoon, ladies and gentlemen, online and offline friends. This is Moey from Dewit Law Office in Beijing. And today I would like to speak to you about the minimizing business scams risks in EU and China transactions. So I will share with you some legal insights and practical guidelines for EU SMEs operating across borders. According to the latest report from EU SME Center, fraud and breach of contract occurs weekly. For EU SMEs, suffers different direct losses ranging from tens of thousands to hundreds of thousands of euros, which is a very high amount. And besides, beyond the financial losses, there are hidden costs for the companies, such as loss of clients or damage their reputations, or management time wasted, or even legal cost. So identifying risks clearly is always the first step to preventing them. So this is why I think a good legal advice is crucial and is also necessary. And what kind of risks can be identified? I think I will share from two perspectives. One is from the perspective for the buyers. Buyers who purchase goods from China, from the Chinese suppliers. The primary goal for the buyers is very simple. So to receive the right goods in the right quality at the right time. But several risks are very obvious. For example, the first one is the counterparty risk. Some of our case we have encountered the EU SMEs, they have faced fake companies or shell companies, which the Chinese supplier didn't exist in the system. This is the very common risk, first of all. And the second one is the payment and performance risk. By paying a large deposit in advance, but eventually they cannot just get the good on time, or even there's no goods delivered. So this is very commonly faced risk. And the third one is quality and quantity control. What we have encountered is that a lot of products purchased, they are less quantity or they are in the bad quality. And goods sometimes differ from the samples, or with sometimes there's no clear inspection standard stated in the contract. So the buyer cannot eventually to make the supplier responsible. I would like to share with you some of the case studies. There are some of the case, like we already stated here in the PowerPoint. Like the first one is an Estonian company paid 30,000 euro in advance, but the supplier delayed shipment repeatedly and eventually disappeared, which is really, really commonly happened. I have a client who has paid a deposit over 70% of contract, and he received nothing. And when he reached us, and we found out that the company they are dealing with is not existed. So they paid to the company's bank account. Actually, it's a bank account owned by another company in Hong Kong. So this is really something that the EU SMEs are facing. They put a lot of, or they paid a large amount of advance payment or deposit, but eventually they cannot get their goods. The second case is that a Croatian company paid 20,000 for the LED lights. And it turned out that all the lights were defective. This is also what I mentioned is the quality problem. And I had a case, I remember the Polish company purchased some copper wire. And when he claimed in the custom, the copper wire was not copper wire. It's like iron wire, but with a copper surface outside. So it's totally the price is totally different and much lower than the copper wire. But unfortunately, because he didn't put the criteria and the inspection in the contract, so it's very difficult for him to get back the advance payment. A lot of cases similar with this. So we have to learn our lessons. So what kind of lessons can be learned? For the buyers, we recommend not paying too much upfront advance payment. Paying a large amount at the start will put all risks to the buyer before the goods are even sent. And it is highly possible that if the supplier disappeared, the advance payment will never be collected. And even if it can be, eventually it will cost a lot for litigation or some legal court procedures here in China. And the second lesson is that supplier stop responding after payment. So once they get the money, the suppliers often disappear. So it's a common sign of fraud. Normally, the case is that the SMEs, they have kind of communication on WhatsApp or even WeChat communications with the Chinese suppliers, but it's not through emails. And suddenly the contact person disappeared, and they cannot find out who is behind and who is this really the party is in the transaction. So I will share with you some of the measures to be taken in a later stage. And the last lesson we can learn is that the contracts is really important. So the contracts are always essential for the SMEs because it is the last guardian for the SMEs to be protected under the law. So we need to be aware that signing a good contract is also the key protections. And then in the later stage, I will share with you what should be mentioned in the contract. And from the perspective of from the sellers, if the SME is selling products to Chinese companies, the main concern is to receiving payments, obviously, and it's receiving the payments in a securely and timing way. So normally the risks are even either the payment delays, the buyers might delay or refuse the final payment after they getting the goods. They often claim quality issues to avoid paying. And also they have also some quarrels or arguments on the problems of the goods. For example, they would like to return the goods, or the goods is has some problem with the custom, then they don't want to pay. And the third one is the fake fee scams, which I will share a case with you. The false fee trap. There is a case that the false fee is asked after the sales and purchase agreement signed between an EU company and a Chinese company. Then the Chinese company said that we need to notarize the contract in China. And the notarization fee is about 20,000 RMB. And we also need some fees to handle the foreign exchange. What do they mean? To handle the foreign exchange, because in China, we have the foreign exchange control, which means we cannot pay USD directly to abroad. And they need to exchange RMB into USD or other foreign currencies in the bank, then pay it through the bank to abroad. And then they say that the bank will request them to have some handling fees for the foreign exchange, which is not true. The red flag is that if you're asked to pay official fees like notarization fee, foreign exchange, handling fee, etc., it's probably a scam because the notarization is not necessarily here in China to validate the contract. the contract, once the contract is signed or sealed, it's becoming enforceable and it's binding for the both parties. Notarization only required for specific contracts, such as the real estate purchase, and normally this amount of the contract is so big, and both parties need to be aware that the contract is so important, so the notarization is required. So never believe that they will need such a fee to perform the obligations of the contract. So if you have been asked these kind of payments and not to this, the counterparty of this contract, is to to someone else, it's likely a scam. So you have to list all the fees in the contract and make sure that the payments go straight to the service provider. If you are going to notarize it, pay it to the notary. And if you are going to pay the bank, then the bank, I think they have the system to deduct from your bank account. So how to prevent being scammed? I think it's very important to build a strong defense system, because the risk management should not begin when problems arises. It must be embedded from the start. So if there are some measures can be taken, I would recommend 6 warning signs. If you are already have incurred such of this kind of thing, I will explain one by one. The first is unusual online presence. I remember I have a client, when they checked with me, I searched they only provide me with the English name of the Chinese company. I asked, do you have a Chinese name of the Chinese company? He said, no, I only have the English name. If you only have an English name, that will be a very big problem, because in China, because the official language is Chinese, so the English name or other languages will not be registered in the public system. So only the Chinese name is registered for the company in our public system. So if the Chinese company doesn't have a Chinese version website, doesn't have a Chinese name provided to you, then be aware they may be cheating on you. So the very first step is to check their website. If they only have a foreign, like English version, I say be cautious, because they don't have business in China. Why they only sell to foreigners? Because they want to hide something. And the second warning is the wrong company stamp. I believe there are some misunderstandings of the company stamp, because we have different culture. In China, it is very important to recognize the stamp of the company, because when the company is incorporated, all the stamps, like official stamp, the company official stamp, contract stamp, invoice, VAT invoice stamp, financial stamp, legal representative name stamp, are all need to be registered and keep the filing to the Public Security Bureau. So these are not carved by someone randomly on the street. It's carved by recognized companies, recognized by the Chinese Public Security Bureau. So only with the seal of the company on this contract, I can say that the contract is valid. If someone saying, oh, the contract, I have already signed the contract, but I don't have a seal, I don't think that is a valid contract, because even if he can give you kind of a power of attorney, maybe it's a fake one. So check the company stamp. And I listed, also I showed one picture here. There are some of the stamp are not round. in red color, like they're stated in English, they're not the stamp recognized here in China. They may be carved in Hong Kong or by themselves, but they're not the official stamp. And the third one is the big upfront payments, which I have already mentioned. Never pay advance payment in a big amount. And the next one is suspicious bank accounts. Suspicious bank accounts, which I just mentioned, there is a case that they paid to a Hong Kong bank account with the same English name of the counterparty. But afterwards, when we check it, actually the bank of HSBC never have such a company open a bank account. So it's a fake one. They opened on the third platform, which have a bank account in Hong Kong HSBC, but they don't have their own bank account in Hong Kong with the same Chinese name. So if the counterparty is asking, okay, I have some problems receiving money to my mainland China bank account, please transfer to my personal bank account, or please transfer to my Hong Kong bank account. Don't do that. The first reason is that maybe this bank account doesn't belong to him and it belongs to someone else, or there is a scam, and eventually there is a possibility that even if the contract is performed and you found out some problems for the contract, for example the quality of the goods, then when you sue the counterparty in the court, they will say that I never received this amount of money. I didn't know where you have paid. So suspicious bank account is also a very big warning. And size of a shell company. There are a lot of size of shell company. For example, we have the registered capital. I will mention it in my next page. The registered capital is required to be paid up according to the new Chinese company law, that within 5 years. And for those companies who already, because the enforcement date of the new Chinese company law is 2024, July 1st. So if some company incorporated before this date, the law gives 3 years transition period, which means in 5 years since 2027, they need to pay up all their registered capital that all shareholders subscribed. If you have checked that this company hasn't paid up their registered capital, be cautious, because there must be something wrong, or they're not compliant with the law. And the last one is the extra fee requested, which I have already mentioned. So what kind of measures you can take? I have summarized the 6 proactive measures. First of all is to check the very important documents, which is the business license. Business license is kind of an identification card of a company. It's issued by the, we call it Market Supervision Administration. And you can see in the business license, it mentioning all the key informations of the Chinese company, the name, the type of company, the legal representative who is representing this company, and the business scope, and also the registered capital and the address. And the second measure, I would suggest that if you receive such a business license, once you request them to provide, then check the business license information in this public system, which I already listed the website. You can scan the QR code on the top right corner of the business license, where you can get the information whether this business license is authentic or a fake one. Or you can type the Chinese name of the company or the United Social Credit number of the company in the system to check all their informations. This website is for free, so you can check the information of the company on the website. The third measure I would recommend is to confirm the contact person's authorization, like whether this person can represent this company to negotiate and sign a contract with you. Whether this person so you can ask for a business card, ask for the email address, not only chat on WeChat. You can ask even for the power of attorney, authorization letter from the company, or you can call the registered phone number in the system to check whether this person is working for this company. And also, I think SME Center is a very good way that you can contact, because they also provide assistance to SMEs to get informations, or your local representative, such as the embassy or consular and chamber of commerce, if they can provide you some information. And also, I think it's sometimes very important, if it is necessary, it's always necessary to have an independent third-party partner for quality checks, for the legal assistance, for like due diligence checks. So the third party can provide you a report or can provide you assistance during the transaction. So as I just mentioned, contract is not something that you can just print it out and sign. It's very important for the cross-border transactions. So normally, these 8 essential clauses shall be included in a contract. The first one is the contract parties to the contract. So after you have done a thoroughly check on the parties' identity, business activities, then put everything of this party to the contract. The second is description of goods. So it's recommend that clearly describe the product details. If it is very important, you can use annexes to the contract to describe the details and also the inspection standards, or the process to appoint a third-party inspection. And price of payment is very important, of course. So arrange payments in stages and use safe methods of payment, like a letter of credit. Don't pay a large amount in advance. And the fourth is delivery and inspection. And sometimes it's better to put a kind of penalty or liquidated damages for non-delivery or late delivery. And the fifth is breach and remedies. So clear penalties for delays and define the seller's rights, and also define the buyer's rights when there are some breaches of the contract. And six is important because the applicable law can be chosen by the parties. If you are not familiar with the law of China, PRC, you may argue with the Chinese party to choose another governing law, like the law of Hong Kong, the law of Cyprus, for example. If they agree, then you can put the governing law clause here in the contract. And termination, explain when the contract can end and how things can be settled. and also general clauses, which are standards covering like important details like trade secrets, intellectual property, and also language, like which language should be prevail in case of there are different, like a bilingual version of the contract. And the last chapter, I would like to talk something about dispute resolution because I know it's not something very pleasant, but it's always something that when thing goes bad. And when disputes arise, parties generally can choose either arbitration or litigation. And sometimes the client doesn't know what is the differences between arbitration and litigation. I have summarized the key aspects of differences. In general, arbitration is more private, is more quicker, and it's more freedom because you can choose which arbitration committee will handle this case. And also, it can be enforced easily over 140 countries because of the New York Convention. And litigation, if you are having a dispute with a Chinese company, I'm afraid that the litigation can only be happening in China. So you have to sue in China, in local court, where the defendant locates. So you cannot choose the court, you cannot choose judge, you cannot choose the language of the litigation. It can only be done in Chinese. So, and also the length of closing the file is quite long. If a company from Europe doesn't have any branches here in China, sued a Chinese company here, the case will be treated as a foreign related case. So the time limit for the judge will be prolonged. And also, if the judgment is made, sometimes you have to apply for the enforcement of the judgment. So normally for the SMEs, we would like to recommend arbitration because it offers privacy and easier to be enforced. So then you may ask how to write a valid arbitration clause because the thing is I encountered that some of the clients, they have an arbitration clause in their contract, but it's not valid because the clause said that they will choose some arbitration center in Beijing. But they didn't mention exactly the name of the arbitration center, which means that because Beijing, we have a lot of arbitration center. We have CETAC Beijing, we have Beijing Arbitration Committee. Which one are you choosing? You have to be very clear that I'm going to choose the CETAC Beijing to be the arbitration center. And you have to define the issues, what kind of issues will be arbitrated. And name the city. For example, CETAC have different branches. Which CETAC? CETAC Beijing or CETAC Shanghai or CETAC Hangzhou? So if you have chosen arbitration as the dispute resolution, then you need to be very clear and you have to make sure that you understand the arbitration rules. And suggested arbitration centers for EU business. Normally, we will suggest for if you don't trust like a mainland China arbitration center, you can go to Hong Kong International Arbitration Center because they are very, very famous and they're efficient. And Hong Kong is an independent jurisdiction, which they also have very talented and professional legal professions. And if you think that your case can be done here in China, in mainland China, CETAC or local arbitration centers also are good recommendations. So you can pick up the right law, for example, the PRC law, and also the arbitration center to help you if there's something goes wrong. So our legal process. So normally we can do investigate background check for the clients if they feel uncomfortable when they have already negotiated with their partners, and we can start the background check, and we can prepare the contract and negotiate the clauses of contract. And we also can monitoring the process of the performance of the contract. So if something goes wrong, which is easier for us to have the dispute solved in a professional way. So in conclusion, I think the best protection is not you ask for advice after when the problems occurs. It's best that you already get be aware that something might go wrong, and you already established the prevention system. And even if there's something wrong, that you can act fast, and you can ask for advices from experts like EU SME Center, and you can collect evidence and keep the evidence. So prevent the problems first is essential for the scams and risks in the transactions. So if you have any problem, you can contact us in our WeChat or email address. Thank you.